The issue before the Supreme Court in Fry v. Napoleon Community Schools was whether parents asserting claims under the Americans with Disabilities Act and Section 504 of the Rehabilitation Act must exhaust administrative remedies under the Individuals with Disabilities Education Act when the alleged injury is disability based discrimination and the denial of access, rather than the denial of a free and appropriate public education. Put differently, the court was asked to decide whether IDEA functions as a mandatory gateway for all disability related claims arising in schools, or whether access based civil rights claims may proceed independently when they do not challenge the adequacy of a student's education. The court began with the governing statutory framework. Under Title 20 of the United States Code, Section 1415, subsection L, exhaustion of IDEA administrative procedures is required only when a plaintiff seeks relief for the denial of a free and appropriate public education. That limitation is explicit and deliberate. IDEA is an education statute. It is designed to address the adequacy of educational services and programming. By contrast, the ADA and Section 504 are civil rights statutes. Their purpose is to prohibit discrimination and ensure equal access to public programs and facilities. The court emphasized that these statutory schemes operate in parallel, not in a hierarchy, and that compliance with IDEA does not immunize a school from liability under federal civil rights law. The court then articulated the analytical framework for determining whether IDEA exhaustion applies. Courts must examine the substance or gravamen of the complaint rather than the labels used by the parties or the fact that the conduct occurred in a school setting. To assist in that analysis, the court identified two guiding considerations. First, could the same claim be brought if the alleged conduct occurred at a public facility that was not a school, such as a library or a courthouse? Second, could an adult bring a similar claim in the same setting? If the answer to those questions is yes, the claim is unlikely to concern the denial of FAPE and instead implicates access and non discrimination rights protected by ADA and Section 504. Applying that framework, the court focused closely on the facts. The student in Fry had severe cerebral palsy and relied on a trained service dog to assist with mobility, balance, independence. The service dog was medically recommended and operated independently of the student's educational programming. When the student enrolled in public school, the district refused to allow the service dog on campus, asserting that the student's IEP provided human aid sufficiently addressed her needs. Notably, the parents did not allege that the IEP was deficient. They did not request modifications to instructions or services. Instead, they alleged that the exclusion of the service dog constituted disability based discrimination and denied the student equal access to the school environment. The school district argued that because the dispute involved a student with disability and arose in a school context, IDEA exhaustion was required. The Supreme Court rejected that position. It made clear that the location of the alleged harm does not determine the applicable legal framework. Applying the Gravamen analysis, the court observed that the same claim could have been brought if a public library or a courthouse barred the service dog. An adult with a disability could likewise assert the same claim. Moreover, the relief sought, equal access and compensatory damages, was not relief IDEA could provide. Accordingly, the court concluded that the claim was one of access and discrimination, not educational adequacy, and IDEA exhaustion did not apply. The court ultimately held that exhaustion under IDEA is required only when a plaintiff seeks relief for the denial of a free and appropriate public education. Where the gravamen of the complaint is disability based discrimination or denial of access, claims under ADA and Section 504 may proceed independently. This holding has direct relevance to ABA in schools. Disputes involving access to medically necessary ABA services are often mischaracterized as IEP disagreements. Fry makes clear that access is a civil rights issue, not an educational courtesy. When the request is for access to medically necessary treatment, schools may not avoid their ADA and Section 504 obligations by invoking IDEA and moving on.